everybody. Welcome to Justice Served Daily. And yeah, we've got a lot of stuff going on. I would like to welcome Mama Bear up here. Hello. Mama Bear.
Hi.
Hello.
Well,
this is a day.
Voice. I'm putting on a nice voice, okay?
This is the day. Lots of stuff going on. And I'm going to try to see if this will allow me to do what I want, but it probably won't because, whatever. Okay, so Mama Bear, if you can keep an eye on the chat if we've got any questions or anything like that.
Sure.
I mean, some of this video itself is going to be reactive because, honest to God, it's not been that long since this all came down, and been trying to watch between if there was anything that was going to happen for Mitch Westerman, and which was early this morning for his pre-trial. And then, as you know, we've got the whole stuff with the case. So we're going to go ahead and I guess find out. We definitely can show the entire video itself. It just kind of depends what you guys, how about our audience? Did they already show all of you guys, did you guys get to watch it? Did the audience people are on right now, did you guys catch the whole video of seeing the trial? So
you want to say do like a 1 for yes?
Yeah, if you guys watched the actual trial thing itself, put a 1 in there. Yes, of course, Jinx. I knew you would.
Shocker there, Jinx.
Yeah.
So yeah, everybody's seen it.
Okay, good. So what I'll do is I'll let it. I think what I'll do is that towards the ending, if there are any of our viewers who have not seen it, or if you're from someplace else you couldn't connect to it, what I'll do is at the ending, I'll go and then I'll show that. Then that kind of makes more sense, and that way you guys can stay on after we kind of yap and talk about it and stuff. So let us go ahead and go through everything that was decided and everything that's happening. That's happened today. So, of course, we had the Indiana Supreme Court to hear the information. So we were in there 11 a.m., which I will say, at least with the Supreme Court, you can see stuff really well. They do a good job and stuff with that, although the sound was a little low at the beginning. But and then, they tell about all the case summary stuff that that's going to be in there. And they do the difference between this and a regular trial hearing in Indiana is a regular trial hearing does not get recorded, and it does not sit there and have a tape and stuff that's provided after the fact. Now, when you're dealing with anything with the Indiana Supreme Court, then they do it, it's public for them to everybody to know exactly what their decision was and based on what. And so but I thought it was I thought it was pretty good questioning that they were asking about on both sides of the case, and trying to find out specific information. Ironically, I've known Matt Gutwin before. I worked with him when I was in a different capacity, and he was actually in a different capacity. But I know Mr. Matt Gutwin. But yeah, I thought it was. I thought the case itself was heard well on both sides. I thought they asked good questions. I thought that was good in there. Like I posted in the community post early, I was like, I, I had a feeling that it was going in the way for the attorneys to be reinstated, and then I wasn't sure. I even when we had kind of mentioned it about the other day on the other show, that I just had a feeling that this was going to end up going this way. And but I guess to start off, Mama Bear, what did you think as far as the questions and stuff were?
Again, I thought they were very fair questions. I think, we watched it together, so I think we both felt that way. We kind of, I think, like you said, we agreed that we felt it was going to go down the way it did.
Yeah.
So I don't think there was a real shock for us for that. So I don't think there was anything, truly out of the ordinary, to be truthful with you, honestly.
Yeah.
When it really comes down to it,
Yeah.
I mean, you always have that, I guess, a little bit of shocking moment, of course, just when it finally comes down. But beyond that, we had already discussed it anyway.
Right.
Correct me if I'm wrong. So
no. I think so the biggest thing that we found out, they waited. They said they were going to give us a information about their decision later on. And so then even the news and stuff like that was kind of like they weren't even really sure, you know what I mean? They weren't even really sure where how long this was going to take. They thought it was going to take a while. And even some of the news outlets themselves were kind of like, we didn't think it would even be this soon. So,
right.
But yeah. So, that's not what I wanted either. We definitely got word down that was coming, but I guess the thing maybe that we share is in chronological order is the additional charges that were dropped.
Yeah.
Before we heard about this. So if you watched the other Olympic show that was done, right? If you watched the other Olympic show that was done, you know that I talked about the charges. We talked about the definition of felony murder versus murder. We, addressed that kind of stuff. And at the time I shared with you guys was that when you talk about that felony murder, you have to be committing a felony in order for that charges to be done. So, right in between, after this was done, we get an announcement. This is the 2 documents of the motion to amend that, and I'm going to enlarge that for I can read it myself. So basically, the state of Indiana prosecutor's attorney, Nicholas McLeland, hereby respectfully asks that the court to have amend the charging information filed in the case October 28th of 2022, and in support, therefore, does offer that on October 28th, 2022, the state filed the charges information alleging these offenses: murder as outlined in count 1 and murder as outlined in count 2. The defendant was arrested on October 26th of 22 and detective with Carroll County Sheriff's Department. Probable cause affidavit executed by the detective, now Sheriff Tony Liggett, and filed by the state on October 28th, 22, identified acts of murder on or about February 13th of 2017. The discovery in this cause also revolves at around acts of murder occurring in Carroll County on that date. The charging information and the probable cause in this matter reflect the charge of murder. Then they have the code, commonly referred to as felony murder, that Richard Allen did kidnap victim 1 and victim 2 by force and in the process of committing that felony. Both victim 1 and victim 2 were murdered. Number 6, the state hereby moves to amend the charging information to add. So they're not subtracting anything. I want to make sure everybody knows. That's why it actually shows 4 counts of murder. And there's murder and felony murder and kidnapping. So now we're adding to the additional counts, which include murder. And if you look at the statute for victim 1, victim 2, along with kidnapping for both victim 1 and victim 2, the state is asking for the court for leave to file their amended charges because the charges are accurately aligns for charging information with the cause discovery and probable cause affidavit. It shows attached because of the clarity of the discovery and probable cause affidavit. The defendant has been on notice since the beginning of this case. Then this amendment does not prejudice the defendant's substantial rights, and that the trial for this matter is 9 months away, giving the defense adequate time to prepare to defend the amended charges. That the amendment does not substantially change the state's theory of the case. So then they show, changing, layering, whatever. So, okay. 1, we're not surprised at all. Nobody is surprised here that the kidnapping charge was added. And honestly, I'm going to say this: I'm not even shocked that the murder charges were added.
Yeah,
because this is what I think is happening. This is what I think is going down. If you haven't watched the show, the marathon show, watch it in bits and pieces if you can to get in there, because I think some of those bits and pieces are going to add up to, I think, what's happening right now. All of the timeline that I show and go through, especially towards the ending that led up towards Richard Allen, the Anthony shots, the development of the Anthony shots, the continued focus of Anthony Shots, who was setting up a meeting and was going to meet with Libby, showed a build-up period of time that, 1, she was being groomed, started at least no later than November of 2016. 2, that the Anthony Shots was communicating with her prior to even that the 13th of February, and not meaning just at the slumber party the night before, but that she was building up to meet with her since he started talking to her that full weekend, starting on February 10th, which is what was deleted off of the phone history from that particular phone from February 10th to February 15th when he got home. In addition to the DNA, looking for how long DNA lasts. When he got home after the questioning on February 25th with the FBI, with the police, asking about the peeping Tom, but more importantly, already asking about the Delphi case. So when we go through all of that, we know, and I feel very confident in that. I should guess that, in my opinion, I'll put it that way. In my opinion, but I'll go back. What we do know is Anthony Shots was going to meet with her. We do know that Libby's friends that Anthony Shots was also communicating with was talking, and they all knew that she was going to meet Anthony Shots. Anthony Shots told them he was supposed to meet with them. But in order to create an alibi, the Anthony Shots responded to the one girl who was at the first slumber party that was on Saturday night, not Sunday night, the one without Abby there, that, he was going to meet her, but she didn't show up. In my opinion, that is because Anthony Schatz is creating an alibi, right? So what does that mean? That means that, again, the felony murder leaves it open that somebody else could have committed the murder,
Right.
and participated in the murder, and or that's why they were only charging him with felony murder, meaning you may have not been the actual so-called murderer, but it led to their murder, that you kidnapped them. They can easily prove kidnapping. Why? Because they've got the video, right? They think that they've got the video, they've got the audio, and whatever else stuff that they have, the bullet, right? They know the bullet is over at the crime scene, whatever else in those pieces that they're going to do. So they have to prove that he kidnapped them, not to murder. Now, what's the difference between felony murder and murder? Well, I don't know. Maybe the death penalty. That's kind of a big thing. So now,
actually, real quick, I'm sorry,
sure,
Jason.
go ahead. No, please go ahead.
Real quick. I was watching chat, and actually Jinx made a really good point, which I didn't even think to look up prior to us doing live, which is the fact, if the two attorneys are death penalty attorneys, can they handle death penalty cases? That's interesting.
That's a good question.
Thanks, Jinx. I didn't think about it before we went up to even look at that. Because again, that could obviously put a delay on matters too. So maybe.
Well, yeah. So yes, I'm going to get into the whole piece of why this is going to be different, because I haven't got to that part yet. But anyway, so that is a very good point. But he just fought for that person, and you don't know at what level somebody can be put at death row. Type of thing. But, and this part is, in my opinion, this part is totally speculation, right? I think that the new charges are because if he's not going to talk and somebody else is not going to talk, then if I charge you with murder, and that's the possibility of the death penalty, then you may open your mouth and say who else is involved. Exactly. Right now, he's not going to talk, right? Why would you talk? His attorneys are making him believe, hey man, we got this. It's Odinism. We got that out to the public to tell ahead of time. And that, that's what we're going. Now, to be honest with you, do they have to go that route when they go into trial? No. They can bring up something totally different. But can I throw this out there to you guys? Does anybody think it's odd that one of probably the easiest things they could have said, that somebody in order to create a reasonable doubt, would be that Keegan Kline, who created Anthony Schatz, was the last person to speak to them before they died?
Absolutely.
Why would they not point that out?
Sure.
Well, you're not going to point that out. Also, if there's any connection and stuff between you.
Two of you.
So, so I think that I think it's on the table because, now they could have found more. I mean, think about all the other cases that we've heard. Like, think about, I can't think of her. Casey Anthony's case.
Oh God, please. Must we?
Well, I mean, just give an example. You got the charges for Casey Anthony. They went one extreme. They didn't go the other extreme. And then so she sits here, and they could only do full-pledged murder and nothing else. And so they had to find her not guilty, right?
Yeah.
So, and by the way, if you didn't watch the video the other night, you need to go look at how when they went to Vegas, they decided to look up Casey Anthony and O.J. Simpson. And then when one of Keegan's responses is actually about O.J. Simpson, it's like, you know what, Keegan Kline, you are no O.J. Simpson. Okay, you're not rich, athletic, or black. So you're in deep trouble, buddy, because, that wasn't going to work for you. I don't know what his logic was to try to compare. Well, yes, he talked to her too online before no, whatever. Such an idiot. So I think also it's just a further function that everybody wondered why kidnap, and I covered that in that other video too. It was brought up, why was kidnapping not added yet? People were inquiring about that. When the felony murder charges that were already on here, they were like, why is kidnapping not there, right? Kidnapping should be there because kidnapping would be the felony that he committed in order to have the felony murder charge, which again, I talk about in the other video that we just did the other night. And that talks about the difference between felony murder and murder in Indiana. Murder in Indiana is the higher charge. Felony murder is that maybe you didn't mean to kill somebody, but they did, right? So like you're part of the gas station robbery, but you didn't shoot the person at the gas station, but you're still charged with the murder because you were part of it and you were committing a robbery. Same difference.
Mm-hmm.
So, yeah. So we now have that those are the updated charges, make it 4 murder charges, 2 felony, 2 regular, and the kidnapping is now added. So we have what they are showing. It was the felony he was committed in order to do that. I think that's, my opinion, I think that's the strategy for it. Mama Bear, I don't know what your thoughts are, but I think the strategy is put them on the table. And if you want us to take those charges off, then you'll tell us the rest.
Yep. Fill in the gaps. Tell us what happened, and we'll take those off. We'll make you a deal. That's my opinion. Absolutely.
And through the other thing, I kind of went through with you guys that if you watched, again, I'm going to keep referring to the marathon show. If you watch the show, I show you exactly when things started dropping for Richard Allen. That supposed Orion system that was found, the tip from Orion, which supposedly then was a misfiling, blah, 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 happened while the water search was going on. How convenient.
Yep.
Then they go arrest Richard Allen. They go through all that. They then finally do the press conference on October 31st. And then on November 1st, 5 charges are dropped off of Keegan Kline. Here's my opinion too. I think that for the defense team, I think they could make it a reasonable doubt against his charges if they don't arrest the Anthony Schatz who made the arrangements to meet. That is in my opinion. Right. I think that's the piece that they're missing. I think that's the reason tip lines are still open. I think that's the reason that they keep going to Keegan Kline, even at the end of last year, then going and questioning him about the yellow app. Right. I think that never left them. The Anthony Schatz communicating with Libby, they have not left over the years. They keep going and going and going and going. And I don't think they've left that.
Interjection here, JSD. In my opinion too, I thought it was, kind of not unusual, but I thought it was interesting for the fact that they moved Keegan Kline just recently out of the same prison that Richard Allen is located in. I think they want to be able to talk to him more freely, in my opinion, and hopefully he'll make a deal too. obviously, to bring down those charges.
Right.
Obviously, since that's his goal with his new attorney, also, in my opinion.
Right.
I don't know
Well,
how you feel about
that's
that.
why I point, I talk about that. There are still federal charges that are going to come down no matter what.
Hmm.
Federal charges on state charges, like I showed, overlap. That's not a double jeopardy. That's not anything
Right.
whatsoever. By the way, hi Lynn and Paige and ATS News and Faye and Daisy and wow. Hello, everybody. Hello, hello, hello. Um, yeah, I think that the reason is there is because they have more stuff on there. I think Keegan, I still kind of have, I'm not 100%. I'm not as big as I used to be in the thought process that maybe it was all him that got to him. But when you look at that timeline of his charges dropped, when he was taken in, all this kind of stuff, and then the weird
Hmm.
of how did we find him? That Liggett just randomly happened to be doing it while the water search was going on. He went to the
Exactly.
Orion, and then finally the Orion system pointed him out, and it doesn't make sense. And then 5 charges are dropped the very next day, and they're CSAM charges. They didn't have trouble with that case. He brought them the 5 of the phones. He
Hmm.
brought the damn 5 phones to them, and they checked them, and they found all the stuff on it, and he admitted it. So
Right.
they didn't have to do anything with that.
Nope.
So, and them searching in the water having to do with CSAM makes no sense whatsoever.
Yeah. And they're not going to waste
Hi,
funds.
Digital.
They're not going to waste funds just to go ahead and do that water search, and for the amount of time that they did the water search, and
Right.
all of the other officers that they had to pull in to do that. There was a reason behind it. Again, we've said this before. None of us know everything that's, that they have.
Right.
And they're going to hold some of that back, obviously, for trial. They're not
Right.
going to show their hand.
Right.
So there could be a lot that they have that none of us have a clue about.
Right.
And nor we should have a clue about.
And I think that's kind of the strategic stuff that they're trying to do when they were working out this case. What happens federally? What happens local? What do they move on first, right? They got to move on the Delphi murders to try to get this person, but federally they're still doing this. We had more busts today that came out news about it, which is going to play low on it because they did. We had more production people busted for it. And it's interesting because I don't pay attention just when they finally got sentenced and all this kind of stuff, because some of them, I report on these guys as soon as they get busted. Well, the other one, got arrested. Like you're not even going to find them yet in the ring near your home yet, because this is when they first get busted. But some of these guys we don't even hear about. And then we go in and we look that some of these guys did plea deals. Some of these guys did, just horrific stuff. They saved these kids and stuff like that. And, when you look though at the timing of when they said they found them and the dates are awful interesting. And yes, Paige, you're right. The biggest thing is the Anthony Schatz, who's supposed to be him, all these weird searches. In addition to that, tries to create the alibi again for the Anthony Schatz by sending Libby messages after he knows she's dead. And he admits he knew she was dead because he was checking Delphi before they left for Vegas, while they were in Vegas, and then after the getting arrested and taken in for questioning for Vegas. He's still constantly looking that stuff up. So yeah, it doesn't make any sense whatsoever.
JSD. Also, Lynn asked a question.
Oh, I'm sorry. I'm trying to go through them.
No. She just put, can Judge Gull have a hearing to disqualify them?
Yes.
And we were talking about that earlier.
That's exactly what we're gonna. So
yeah.
So during the Supreme Court discussions, one of the things that one of the chief justices talked about is that, well, one, they were talking about if they reinstate them, just because they did not, they really kind of felt like she didn't go through all the steps necessary to remove them. And, you know, all of us know that, and they brought it up. I don't think very aggressively, honestly, but they brought it up that while she was telling them that you know, they were going out to trial, because remember who we didn't see, the prosecutor was there to bring out witnesses to talk about the leak, which is ironic because we would have actually learned way more about the leak if those witnesses would have been able to go up there to talk about what happened, who got what went where. We would have all known that if the attorneys would have went out there. But so the attorneys felt like, well, no matter what, she's removing us. And so then they said, even though that they stated not even going out there to hear the evidence, where they could have fought that, or what even the Supreme Court, or I'm sorry, the prosecuting side that argued was, well, if they went out there and they heard all of this, they could have asked for a continuance.
Right.
Once they had heard anything that they wanted to fight back on or whatever. But they did talk about how much prep time the defense team already had, because they remember, Baldwin already went and got another attorney to represent himself of what happened. Then you've got ROZZI, who went and met with Richard Allen and sat down and told him about the leak and asked him to write the letter. So they were already doing stuff to prepare for what was going to happen, because they said Judge Gull had already notified them. So one of the chief judges did state that it is not that if they go back to court and there's something that continues and stuff like that, and she's logging this stuff and she files, you know, against them as far as not following procedures and has official hearings and stuff from that can still happen.
Right.
So that was kind of left open on there. So, and kind of, I guess, jump ahead as far as from that concern. So if you don't already know, they did reinstate both the attorneys to go back into place.
Right.
They denied two things, which one of them I think is funnier than shit, but whatever. One of them is they denied about Judge Gull. They are not removing Judge Gull. And they, you know, they don't feel that Judge Gull hasn't done anything wrong, and that Judge Gull herself, you know, did not do the necessary filings and having a hearing about him. What they did was incorrect, but that they can continue. And then the other one is for the right to a speedy trial, which is a joke by itself, honestly. I mean, it's
file for a speedy trial.
Yeah.
I mean, hello.
Yeah. So, and I want to show that. So we had, let me see. There we go. We have info here that I just wanted to bring up, and I will go back where I was, maybe, kind of. Okay, this is what I want to show you. All right, so if you recall, before all this other drama started, when they got assigned, they asked for more time before the bail hearing and the actual jury trial. So, and I think this one is let me see. I think this one has no. This is the motions.
Sorry, honey. We went ahead and then made you go back. Apologize.
Yeah. No. This was the scheduling defendants. The jury trial is scheduled, and about talking about how they're not going to be ready for the jury trial. And that was the big thing that they talked. So this is the one I wanted to show. I think we'll know if it pops up or not.
It's kind of one of those days, honey.
No kidding. It's like this case just kills you. Oh, well, great. Now I clicked on a commercial.
We're not seeing anything, hon. I'm just letting you know. I don't know if it's because you have Shane's comment up there.
Oh,
or I don't know.
Hold on. I know why.
Figured you would.
Let me see. Sorry about that, guys. And sound would be helpful.
Nah, we don't need that.
Yeah, why not? Okay, why is it trying to show me this? I don't want to see this.
Consumer cellular.
Now when I pull it up, it's like, no, okay, cancel. Yeah, that was a nice one. This, it shows we've got, let me try this again. Let me check if I can pull this up. This is like the initial, when they first got there, and they're arguing already about they're not going to be able to get this trial done, right? They're not going to be able to be ready by January. And if you recall back from the case, which I know a lot of you guys following it, you know, they were sitting here already like arguing how they weren't going to have enough time. Then they were arguing about stuff for not enough time for stuff also because of discovery. And then that's why we had a new order that was done because of discovery. So, and then that's when they filed. And the only thing ever that the defense did want to be hidden is that the defense wanted to be hidden what could cost $1 million in expert witnesses to fight some of the evidence that was against Richard Allen.
Yeah, absolutely.
So that was kind of a big thing as well that they did. But they're arguing this speedy trial, the same function. Sorry about the noise. But in the same function, look at the dogs. They're so cute.
The Subaru Outback Wilderness.
Cuter than a couple other people involved in this case, for sure. Sorry, did I say that? I'm sorry, excuse me. I apologize.
Convince a judge to use public money for his expert witnesses.
But how much money and what type of experts? IT-Mate's Richard Essex went looking for those answers.
Allen's court-appointed lawyers don't have the resources that the prosecutor's office has. In a closed-door meeting, it is expected that Allen's attorneys will lay out their defense strategy, which is information they don't want the public to know or the prosecutor.
Generally speaking, the prosecution has the advantage in cases like this because even a small county has more resources than an individual when it comes to waging a battle in court.
Richard Allen's lawyers, Andrew Baldwin and Anthony ROZZI, who once argued to have records unsealed, are asking the judge to seal their request for more public funding. In the court documents obtained by IT-Mate, they are asking for money to pay for expert fees, expenses, and investigative costs. In making their argument to the judge, Allen's lawyers will have to identify the experts, how they plan on using the information to prove he didn't kill Abby and Libby in 2017.
They'll have investigators to go out and talk to witnesses. There were a lot of people involved in the search for the girls when they disappeared. There are going to be all kinds of records that have to be collected. You're going to have paralegals assigned to the defense team.
The prosecutor's office is required to eventually hand over all the evidence it has in the murders to Allen's attorneys. But this is not a two-way street. Allen's lawyers don't have to share everything until it's presented in court.
I'm sure one of the first experts they're going to get is a ballistics or firearms identification expert concerning that unfired round that was found at the scene where the girls' bodies were recovered.
Money is the great equalizer for any defense. Allen's attorneys will be asked by prospective experts if they can afford the fees. And the cost of the prosecution is also coming into play. A few weeks ago, the Carroll County Prosecutor's Office asked the county for an additional $40,000 to cover expenses. Crawford is a former Lake County prosecutor, and he believes that Richard Allen's defense and prosecution could cost taxpayers $1 million, double that if the prosecutor seeks the death penalty.
And I'm sure that the powers that be in Carroll County are trying to figure out if they're going to have to float a bond issue or raise taxes to pay for the prosecution of this case. Unfortunately, I feel in Indiana, we don't have a mechanism to help small counties prosecute sensational cases like this. We don't have the financial ability to help them.
The Carroll County prosecutor said in court that he believes that others are involved. Every arrest that leads to a trial could cost Carroll County taxpayers $1 million for each arrest and trial. In Indianapolis, Richard Essex, Wish TV, iTeam8.
Discover the only interactive crime map in central India.
So you've got where they, again, we're talking about that they think somebody else is involved with this. And, when you think about who else is involved, the only person I go to is whoever the Anthony Schatz is who set the meeting up. So what I've got right here, this is the Indiana Supreme Court. This is the published order. And I don't know how well you guys can see this or not. It's always hard for me to tell. But I'm going to try to see if it'll let me do anything.
It's on the smaller side. Oh, there you go.
Whoa. Well, now
There
it's
you
not
go.
on the smaller side, but I don't know what it did. It's on the way too goddamn big side, but hold on. I'm going to only press it a couple times. I was worried it didn't take what it's supposed to. The rule proceedings, original account for prohibition is arguments to order that the trial reinstate several. Damn it. Damn it.
I love when you argue with yourself.
Oh, God damn it, computer.
It was like our arguments all day.
Yes. Shit. Oh, I'm going to hurt somebody. Okay, wait a minute. There's what I wanted. Okay. This is the published order. Okay. There's two different ones. There's a denial and the other. So this is the one asking the court order for the trial court to reinstate the former trial counsel attorney Andrew Baldwin and Brad ROZZI at his court-appointed counsel, order the trial court to commence realtor's trial within 70 days from the insurance of the writ and the remove of the special judge from the, we're moving Judge GULL. So after considering that, all things learned, the arguments, of course, a majority of the court grants the petition to writ of the realtor's request to reinstate attorneys Baldwin and ROZZI as his court-appointed counsel. The court unanimously denies all other relief sought. Now, that's interesting. So if you go to what was read as far as what they grant, and then, but they talk about how the court unanimously decided on the court promptly issue a written opinion explaining the reasons of for their decision of the court. This was meaning about Judge GULL and about the 70-day in there. Now, one thing they made a point of during the actual Indiana Supreme Court discussion was that they never filed for a speedy trial. You file information that your client wants a right to a speedy trial, you're ready to go to court, and then you'll go to court in 70 days. So for the side of the realtor speaking on their behalf, he was like, well, they were going to be doing that, but they didn't. And we all know that part of the stuff was that they originally were telling the, Judge GULL they weren't going to be ready. And then they delayed it. And then they, there was other things they kept doing that was delaying about just the bail itself. And then the bail got pushed back. So
Right.
once the bail got pushed back, to hear all of that, and they, were arguing about the probable cause and all this kind of stuff. They want the probable cause thrown out. They want all of this stuff thrown out. Then they're like, they never filed for a quick hearing. Now, so that's thrown out the door. So they do have the other different stuff of the published order of deny. It goes through a full detail, of that information. No, we're not ready to go there. So yeah, they unanimously denied removing Judge Gull. They unanimously denied the 70-day trial, according to them, a quick trial, which they're not denying them a quick trial. They just never, you can't ask that you want a quick trial and you never even applied for it.
Exactly.
Sorry, Shane, I kept your name up there the whole time. You probably didn't even, like, what is she doing to me? Leaving
Well,
my
we love Shane.
We do love Shane. You were
He's our
highlighting
other-
Shane.
He's our other across the pond person, like our Paige, like our love bug. Miss you, Paige. We missed
They
her
are not.
today.
Hey, Chris Owens.
One of the things that bothered me, JSD, and I don't know if I mentioned it. I think I did earlier when we were talking, but what really bothered me
I'm trying
was,
to check what Chris is asking Paige.
Sorry.
Hold on. Do we have secret access to the unreleased files and documents or something? No, but we have
do
a lot of info.
research.
We do have a lot of info, and we do show, we don't make it. I will say this. One thing we're different from other shows is we don't make up shit out of our ass. We do not sit here and try to tell you something. If it's in our opinion, or if we're speculating, we definitely will tell you, hey, this is just my thoughts or in my opinion. But I mean, that's hell. That's why my shows take so long. I'm busy working and getting all this stuff that we gather all together in documents and we place in our Discord. And then when we're ready to do a show, we sit here and put everything out here.
Absolutely.
Keith and Kane did not know their real names. He busted some. Yeah, I mean, we don't know what names are in there. And like we did on the other show last night, when we talk about that, the information that the police go over with Keegan Klein, and he denies knowing, like, of course, he's a liar, right? He is a liar. Because for years prior to Anthony Shots being ever created, which was in February, the 1 year from when the girls were dead, they had it already made up by February 14th of 2016 when it was created, according to the subpoenas issued to Instagram and Snapchat from the FBI. So that's when it was recreated. But before then, Emily Ann and Kegan's actual things used to talk to girls, and then Emily Ann would forward those to Keegan, and then Keegan would turn around and start asking them, will you have sex with my dad? And would try to be setting up meetups. So that was kind of their pattern of some stuff that they were doing, right? And say, hey, would you, and meetups, I mean, because he's asking, would you have sex with my dad? So then you've got, here's these new, and then what does Keegan say? Oh, I don't remember, I don't remember Libby, but he sure remembered her friend. He thought Libby was annoying. And that's why he says he blocked her. He didn't block her. That's how they had all those social media accounts going to her.
Absolutely.
And so I think that the reason there were two phones logged in at the time is because there were two different people using the Anthony Shots profile and sitting here communicating. And one is talking to one girl at the slumber party, and one person is talking to Libby at the slumber party. That's slumber party 1. And then suddenly the second Anthony Shots is scheduling to meet up with Libby who Libby tells that same girlfriend she's staying the night with that she's going to meet up with Anthony Schatz. And that same girl addresses it with Anthony Schatz. And that's the girl that he tells, oh, well, yeah, I was going to meet up with her, but she didn't show. That's why. Think about that. That to say that to somebody for no reason and admit you could have possibly been there, which you're admitting you were there, but she didn't show up, is stupid. But it was, again, creating an alibi for Anthony Schatz.
Yes, he was trying to do that a lot.
I think Keegan Kline I think he's got moved because of the possibility. Remember, he got overcharged for being a first-time offender of CSAM. So I think they were using that because what happened, I've shared with you guys, by the way, if you don't look at community posts, which I know I'm horrible with that for YouTubers I follow too, but if you don't, I always have the updated latest as it's breaking news that always is in my community post. So please always at least go check those when they're coming out. But so when Keegan is getting moved to Michigan City, which was not his choice, but right prior to that, he did get a brand new attorney, which is up in the northern part of Indiana. So when he gets this new attorney, this attorney specializes in working appeals. Well, that means he's going to be talking to and dealing with the police again. And guess who I think is going to come in there and say, tell us more? Because I don't think the whole deal went through. I think he told them a little bit enough, maybe even the enough that got them to Richard Allen. But I don't think enough to tell them who was the Anthony Schatz who scheduled the meeting with Libby on the bridge.
Yep. Agreed.
Active, so to speak. Yep. Looking to confirm that second person. Yep. And remember, when he got first arrested, they didn't know about all the rest of the CSAM yet. They only knew about Delphi and they knew about the Peeping Tom, which is enough. Their concentration was on Delphi. Then not till 2020 do they check the phones. And they have more stuff and more details and stuff about it.
Absolutely.
Leaps came out in Westerman's proceedings today. No. So that was the other thing. I don't know if this shows. Let me check if it will. If I pull it up or not. You tell me, Mama Bear, if it shows or not. Does the My Case Indiana show?
Yeah.
Okay. Yeah. I just pulled this update here. So 9 a.m. today, Mitch Westerman, aka Leaker, from the Delphi side, who used to be an employee of Baldwin's and used to, and is friends with him, who admitted to coming into the office and taking photos. He knew of the stuff because Baldwin was talking to him about the case. He had this stuff out, and then he says, unbeknownst to him, that somehow he not only took pictures of the crime scene and then leaked them, but somehow he also knew the whole defense strategy. And the reason that we know that is because Westerman was sharing that with,
well,
I'm trying to remember what we call him. Hold on.
M?
No, is it M? I thought we called him R.
Yes, he's R. The other one is M. You're right.
Okay. So R, I don't want to expose that. If it comes out a little more, because there's a lot more I know about that person, but I don't want to go out there. The gentleman who Westerman shared the stuff with is the one who commits suicide. He also lived in Hamilton County, Indiana. And And he's the one, of course, the dog. Everybody say hello to the dog. Hello,
Hi.
Dumbo. Hi, let's park right
He, al-
now.
he always has to put his 2 cents in.
Yeah,
Always.
he thinks the same way. So Westerman did show up in Superior Court 3. I'll show you here. These were the latest updates that were in his case file. I put this in a community post as well to remind you guys about this case and what was happening with it. So there was even some media and a YouTube show, a media and a YouTuber who requested to be there as far as videotaping, and they were both denied, as you can see here. And this one was a pre-trial conference, so there was nothing huge or something in there. It lasted literally 5 minutes, and that was it. Nothing else came out from it. So they did have discovery materials that we know that came out that we obviously haven't been able to share because they don't want us to see it. And I think there's just more and more that's going to be shared about that, and see if he takes this all down by himself or not. But that is the stuff that was going on with Mitch. So I'm hoping we're going to find out a lot more. His next date is March 7th. And that's when we'll know more about him as well. Yeah, I missed what she said, so. Sorry, guys. I am really slow at catching up with everybody's stuff. Yeah, I don't think if you have not seen about the stuff for Orion system and how that works and my thoughts on the Dan Dolan and all of that, I've got a video on that too. If you have not seen the breakdowns of all of the information bit by bit on Keegan Klein's phones, I have a video and stuff on that as well. So,
yeah, the Orion one was really good.
Shane, I absolutely agree with you. This is a game of chess.
Mm-hmm.
It is a game of chess.
Absolutely.
And I think one thing we have to remember is we have not seen any of the evidence that has been captured by the police.
Nope.
And the FBI and all of it. So you know what, Faye? I've used that thing where it's supposed to take, write down when you say something. I've even read transcripts of people that have that. And I don't know about you, but when I see it, first of all, it misspells things and it irritates the shit out of me. Second of all, it's like, did I really pronounce it to sound like I'm saying that word instead of this word? This case is exhausting. It is exhausting. But I will say that my restoration came when I saw the additional charges come down of him getting, finally showing the kidnapping charges.
Yes, that was.
This is why it's considered conversion.
Exciting.
He stole. They're considering it that he stole the images from them based on what was written that Baldwin wrote, and based on what his own statement, what Mitch Westerman just dropped on his sword and said, this was all me. I took it. I went in there. I took pictures of it and I sent it out. That is why it's considered conversion. He stole the images. I don't know what happened, but Faye was laughing at you. That's all I know.
Everybody's always laughing at me. Thanks, Faye. You know, I love you.
Yeah, I can't wait till we hear all the rest of the stuff either. That's the thing is people are trying to make decisions and they don't know all the stuff yet. And thank you, Jinx, always for coming in and reminding me to please hit that like button and hit subscribe. I'm horrible at that. I'm really bad.
Yes, you are. I agree with you.
God, thanks. I'm hard at asking people to do that, but it does help. I mean, it does help. Kept a knife or some electronics evidence on phones and let's see. Yeah. I mean, at first, honest with you, I was a little bit excited. I thought maybe he got charged for some other murder or something. They figured out that maybe was committed or whatnot, but I don't think they would reveal it like that. You know what I mean? It would have to be a total separate charge from it, everything. So, sorry, I'm trying to go through everybody's stuff, make sure if I see any questions. Let me try to do that here. Let me go. This is a big one.
Well, that's good, though, Digital. I like that statement.
The skip, he was talking about to the trip and a knife and a footprint of the scene. Hadn't heard it before. I haven't heard about a knife at the scene whatsoever. I don't know about a footprint in there. I think that would be hard for them to prove because of how many volunteers were walking around looking at everything. So, but as far as what was in the water, I don't think they're looking for something for CSAM in the water. And it was said about it's related to Delphi. So as far as it going back into that, now we've got those attorneys back. How long do we sit here and think they're going to ask to have to do the trial?
Whew.
Right?
Oh,
they said it was.
70 days.
Look how long they've already been assigned it, right? And then they had that special order that was done that the prosecution had to have all of the discovery to them. Now, and I want to make sure everybody stands. They asked for all the discovery that they had at that point. That does not mean that they have to turn around and they can't find something else, right? So if something digitally pops up or like another witness comes up, that doesn't mean that they're set that they can't ever bring anything else. But basically by that point, they had put a judgment in that, okay, by this date, November 1st, I believe was the date, that prosecution had to have all the information they had in discovery had to be given to the defense team.
Yes.
So this all went down to up until October 31st. So they said they wanted the thing in 70 days.
Well,
they only need
we'll
70
see.
now. What does it change? You're either proving it or whatever.
Mm-hmm. Should be
Yes,
interesting.
Miss ATS. Man, I've been wanting to sit here and do something with ATS forever, and maybe one day we'll get to do something, but sorry, I'm trying to catch everybody. Hey, look who's here.
Oh, Darren. Hey,
Hi,
Darren.
Darren, how are you?
Haven't heard from you for a while, hon.
Yes, they are reinstated. They got reinstated. The judge is staying. There is no hurry up and speedy trial in 70 days, Darren, because they never frickin' filed for a quick 70-day trial. They can't force to ask for one when they never filed for one. Never happened. So, but they dropped new charges. So now he's got 4 counts of murders, 2 felony and murder and 2 regular murder. We know that Mitch, the man, showed up for 5 minutes. They didn't let him have a camera because they were worried he would take pictures of something and share it with others. And yeah,
It's just
who was the
crazy.
man he was talking to about with age girls? Yeah, got how many that on alien, right? And that's what we went through, right? The stuff that I only showed that one section of Emily Ann was talking to another so-called female profile. And for days on end, they were going back and forth trading links to Dropback accounts that included images and videos. That charge alone is called child pornography distribution. What was Keegan not charged with? He was not charged with distribution of child pornography. He was charged for solicitation. He was charged for possession. He was never charged with distribution. So either they think somebody else who's using Anthony shots or Emily Ann is doing distribution, or they're waiting for the federal charges to drop from that. Because remember, they only, what we covered in that other video, they've only figured out who 6 to 7 of the 15 victims Keegan Klein admitted to having that lived here in Indiana. Which that's heartbreaking in itself. And then when you get to that, Cecil, the head of Internet Crimes Against Children, says that Emily Ann is the one who's speaking to girls all across the country, and that Emily Ann is also trying to meet these girls and get them to have sex with what she's calling her father in the information. Well, in order to identify children from all across the country, you have to get NetMec involved, and that's all federal.
Yeah. Absolutely.
Yeah, I think people are going to talk. And let me say, if Keegan was protecting anybody else who is being the Anthony Shots profile, that love affair is going to be over, because he's facing 40 years. He's never coming out when these other charges hit him. He doesn't feel like anybody gives a shit about him, because guess what? I just showed you guys the visitation log. Who was visiting Keegan before? Not Tony. Not till right before the water search was going to happen. Yep. I'm just catching anything. Let me know if you see any that I miss. I'm trying to go through. I appreciate you guys all being here. They were using metal detectors in the water. Absolutely. Dive team, metal detectors, and then they had all this metal and stuff that was pulled over to the side, but people couldn't tell if they were taking something or not, because they had buckets and they had bags, and so they were putting stuff inside the bucket, so people didn't know what they grabbed or what they didn't grab. I'm sure he didn't go tell them, oh, here's I have a CSAM USB drive sitting in the water. There was nothing he could do to help with his CSAM stuff. They already had it. That February 25th, they were shocked. They did not think anybody would have a clue who they were and what was going on. The arrested Tony when Tony says, oh no, I don't have an Instagram and Snapchat. It's my son's. So they only grabbed Keegan's phones and his iPod and his tablet. What do they leave there? They leave, they leave the iPhone 5C, which they tried to claim was a phone they found in the vehicle in Vegas. And 2, they leave Tony's laptop there. Which, come on. I mean, even if you only think it's Keegan, you should be picking up that stuff.
I just shake my head.
I know it's
you can't see me, but I'm doing it constantly right now. Oh God, take the wheel.
Oh, Shane, I'll go subscribe to you, Shane.
Aw.
Yes, Darren, we've missed you. Missed you a lot. Now that the new year's in, hopefully everybody's ready to get back to work on all this stuff here. There's so much.
Yeah. No kidding. And every time we want to try to work on something else.
Who is she talking to? Are you talking to me, Faye?
Oh,
I don't know who she's talking to.
I don't know. But we want to work on something else on JSD, and then
well, it's every time.
It never fails.
The only time that gets in there, I mean, is when we're working. You know, if it's a family case, then you know that one's a little harder because that you know that's something that's going on. Which there's so much Oakley snow.
Oh, God,
you know, we've got that's sitting here coming in. I'm going to be working with Valerie Tyndall's family and following that case, and the guy busted for that, who was the neighbor who used to employ her since she was 15 years old, and he was the murderer. I know you guys saw that little bit about that case and stuff too. Obviously Deborah Fulton is always going to be there because that's a case that really, really needs to be solved. I know people asked about the Jordan Sofer case and want more specifics about that. We'll share some details and stuff and things like that in there too. So yeah, I mean, I guess to say, I think in my opinion, I think what the defense team, myself, I think the stuff and the antics that they were playing, you know, when you later, I thought it was like, oh God, when they first were assigned and they did that press conference and came out and was like, well, there's not enough there to arrest him in the probable cause affidavit and blah, 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 blah. Of course, they're going to say that. That's the defense team. They just got the case of, you know, whatever, and that they were talking and really focusing on, which I find interesting. They were really focusing on how Mick Leland said during that press conference when Richard Allen got arrested, that they're looking for others. They're looking for others involved. And, you know, then you got Doug Carter, who says, we want to make sure we have anyone who is possibly involved with this case. So that's why as you can see, I have the Abby and Libby line still going across the bottom. They still are investigating everything that's going on and ins and outs of this, because this is even bigger. Like they've always said, it's bigger. And I think even the CSAM is bigger. When you talk cross state lines and people sharing links and all this kind of stuff, you are talking a CSAM, child petty ring, all of that stuff is engaged and involved with that. And, you know, I mean, Keegan got his buddy who used to give him free pot, his whole family and people busted for drugs. And, you know, then his buddy in Vegas who got arrested, who used to be his roommate out here and then went out there, who also formed a photography business, just like Keegan said he had a photography business while he was in Vegas.
How many people have photography businesses?
I don't know.
Really?
I mean, I think the funniest thing was his interview with the cop, and he's trying to describe how they had that pot delivering business, and it was a subscription business. And then what they do is, because you are a member, then they come and they bring your pot to you free, and it's supposed to be like for the elderly. I wonder what the cutoff is for somebody to deliver your pot to your house. Is there like an age cutoff? I mean, is that like you got to wait till you're like on, you know,
you're on Social Security?
Is it a Social Security benefit?
Oh my gosh.
Oh my Lord.
Yeah, it's like, what retirement age is, what, 68 and a half years or something? So, you know, maybe past that point or something. You're senior.
Oh my God. Yeah. it cracked me up. Even the cop was like, "What the hell is he talking about?" It's like, he was just like, the cop was like, he just like, "Oh, really?" He goes, "Well, did you have to apply for a business license?" "Oh, no, we don't have to apply for a business license for that."
And don't forget, he can perform weddings. So
Oh,
if
yes,
you need,
we did talk about that. The only real reason he came back from Vegas was to marry his mom and stepfather, because he is an ordained minister. Everybody, I think for him to bring pot to your wedding, that's an extra fee, or maybe you get a discount if you're a member.
Pictures, and he can take pictures of the wedding too. I just can't. Please don't start. We can't start again like the other day.
Well, I mean, first of all, don't you want to be the caterer at that wedding? I mean, he's taking care of the ordained ceremony, right? He's going to take the pictures of it, whatever. He's going to be your band because he rocks out the music, right? He creates his own music.
Oh, that's right. Yes,
right.
He's a musician
And then he's selling out the pot. So you want to be the caterer for that get together, because they are going to eat lots and lots of food, tons of it.
I'll bet they have brownies.
Oh my God. This is what happens when we're trying to catch up all day with this. Oh my Lord.
Oh God. I needed to laugh after today though, JSD. I'm sorry.
Oh my Lord.
Oh,
Jesus.
God.
There's so much anxiety built up from it, but yeah. Yep, absolutely. Well, what I will do now, first of all, before we do this, are there any more questions and stuff like that? Because what I promised I would do is, anybody who did not get to see the actual video of the Supreme Court case, I'm going to show it now. Can't wait to get old. Yes, you can, Shane.
Trust me, it's not fun, Shane. It ain't fun.
Keep it. Shane doesn't want it. You don't want to be old. All right. Well, I'm going to go ahead. I'm going to show the video itself here. And then I will see you on the other side of that. If not, if you're just catching, you can back up and stuff from that. And we're going to go ahead and watch this real quick. It is, though, about an hour, but I'm not going to let it stream through like the little edge parts of that. I'm going to get it in the main part of what they talk about and what's going on. So, all right, let me pull this up. And let me take that down. All righty. So this is going to be the actual Indiana Supreme Court listening to both parties of the case today.
Good morning and welcome. We're here this morning to argue in the case of State ex-rel Richard Allen, relator, versus Carroll Circuit Court and the Honorable Fran M. GULL, respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winicky. Good morning, Ms. Winicky, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, at council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. In a council table, we also have Chris Stake, who's also here on behalf of the respondent. Correct. Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserve that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that You
have a lot of concerns, but you've got a lot of concerns, and you do a nice job laying those out in your brief, but there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level?
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they
from
sat
being
on it for they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and ROZZI and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and ROZZI on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judges. I'm aware of that. I know what's happened. I'm ready to ride or die with these lawyers.
I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclose those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said you're grossly
But
negligent and
the
incompetent.
lawyers-
I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, because she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys BALDWIN and ROZZI, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action, the judge. I'm going to go out there and I'm going to say these things. And Mr. ROZZI presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Got a
those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
my
Amendment
concern is getting
requires.
this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
A lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just something like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not affected. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think that our rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. So I think, but other conflicts are waivable conflicts, and other than that one rare exception.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, Just no, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waivered. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So
well, Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did?
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance to counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, it goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance to counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive, you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples, these are good examples of that. And that the inadvertent disclosure of pretrial discovery has the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and ROZZI developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial has been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
I'm just pausing this right here because this is such bullshit. I just showed you guys that the actual attorneys kept asking for delays and asking for that they weren't going to be ready, and they asked for they weren't going to have enough time to get prepped. We have videos of them stating that. It is in the mycase.in.gov stuff for Richard Allen that they kept filing stuff to continue and delay the bail hearing, just the bail hearing that they were trying to get in addition to stuff. So they were waiting for all of that to kept getting pushed back. And then when they even scheduled for January, we have them stating they were not going to have enough time to prep. So now here they're trying to claim, this guy's trying to claim, well, it was really going to hurt the case. And, we didn't even know if October, if we could even get October. So now they're trying to say like it's not even, the case is not even going to happen in October of this year because of it. And that's such a freaking joke to even say that stuff in there and to say, well, yeah, they wanted a speedy trial. They didn't file it yet. Actually, if you think about that, they weren't filing their stuff for their own client, were they? The client sits here and they said they had it for over 2 months, that Richard Allen signed, that he just wanted to get a speedy trial within 70 days, and they never turned it in, and they never filed the paperwork for it. because they don't want him to do that. They don't want him at that point. He'd already confessed and stuff like that during the spring and April and stuff. We later find out about all that stuff where he called his wife, he called his mother. But so they are talking about doing what your client wants to do, yet they didn't file I want a 70-day speedy trial, hanged on to it for 60 days. Wait a minute, doesn't that violate his rights of having a speedy trial? If you don't even file what the guy's asking you to file, didn't you violate his rights? And now you're blaming Judge GULL for violating his rights to have a quick trial.
Absolutely.
What a bunch
Can
of
I add?
crap.
Can I add one more thing to that too, JSD,
Sure,
please? One thing that just bothered me too was, how he was claiming the fact, or they were claiming the fact that he was having mental incompetence and all that kind of stuff, right? And that was such a big deal and all this. But then yet he's competent enough to write this letter saying that he wants to continue with his previous attorneys and blah, 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 blah. I mean, come on. It's like you want your cake and eat it too. You're incompetent, but you can write this. I don't know.
And here's the thing. I mean, and honestly, what I'm kind of surprised, I guess, they're not going to argue it this way because they're only, it's the Supreme Court. They're not going to sit here and ask them more questions about something. But Richard Allen only knows whatever they told him.
Right.
He only knows whatever they admitted to him or said that he did, unless
Absolutely.
Richard Allen already knew what they were going to plan on doing or whatnot. But, when you look at it, you're talking 60 days back that, here's a guy who he's been seeing what evidence that the prosecution has against him. He knows what stuff's going on. He doesn't want to be in there anymore. And I know there's a lot of people who are like, oh, well, he's sitting here in a prison versus jail. Well, we can go back to look at this, and let me remind everybody why that all happened. The reason that happened wasn't just for the pleasure of Carroll County or Delphi to just get him out of the jail. The reason that also happened, if you guys recall, it was when the first actual judge, right, Dieter, who was in charge of the case, actually sat here and had to recuse himself from the case. Because if you remember, and I don't remember the exact terminology, but they talked about the bloodlust of the public and about wanting info and stuff about the case, and that they were fearful because of how much stuff was, out there and everything back then. And that is when they decided there is no way for us to safely protect him because we do not have enough personnel to watch him, to protect him from everybody in the county that he's going to be in contact with, where he is being accused of murdering 2 girls. And then you have death threats and all kinds of weird stuff that was coming to the first original judge. So the judge dismisses himself, and around the same time, right before this, then they decide we don't have enough people. We don't have a way to protect him. We need to put him in more protective custody. That's why he was sent to the prison. Yep. He was separated. He's not near everybody. He is separated from people. And then the attorneys argued about, like you just brought up, the mental health. Well, the difference about mental health is that in jail, you don't get mental health services. They do have it in prison. Absolutely. So when they send him to the prison, he has access to doctors, to medication, and to mental health assistance because he's in the prison. And it's not in a jail where they don't have enough personnel, and they definitely don't have enough personnel even to transport you to go visit somebody for mental health back and forth either. So that's the reason that, kind of all happened is, going on too. So let me.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and ROZZI back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance.
But I'm really
of counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice. That's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat, as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case, saying a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel. What Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly then open up the floodgates, because
I'm going to go ahead and forward for when the other lady comes up. Angela Sanchez, she is for the Attorney General side.
Counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up.
So right there is where we bring up that the chief brings up that if they put them back in place and she finds that it's in there, and then she goes ahead and then files against that, files of the not following procedure, then she goes ahead and does that anyway, if she continues to see that, and then it's followed in the way that they want it to be documented, basically, and asking about that. What would be wrong with that?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which The state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's a mistake made in the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly significant,
default rule,
weighted.
something like it.
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what they court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte on her own motion disqualified based on her finding, her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in,
But for these reasons, it could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm
in these
clear,
cases.
you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's a writ. There's no order, there's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel.
Appeal that. There is nothing stopping further actions and motions.
All right. Well, I appreciate your patience, especially I know there's people who have watched it. There's people who haven't watched it. I will make sure that this link gets in there for everybody's fabulous viewing pleasure, if you'd like to continue to partake in that. There is something that I got that I want to share with you guys. But I know, again, I don't know what, your thoughts and stuff are on that. So obviously the Indiana Attorney General's office, who was testifying in there, was basically like, hey, we really can't do stuff because there wasn't filing for them to really base stuff on. So, that's where they were on that. But I've got something here that you guys need to see. It's relative to the time frame of the murders and information that has come out. Now, I know lots of people have heard about this information if you followed the case for a very long time. This is confirming information about Richard Allen immediately days after the murder that I want to share with you. And let me make sure I get this up wherever it is. No. Okay. And I dropped it in here. I want to make sure I pull this up. But this really talks about and proves information about a domestic violence incident with Richard Allen. And it literally happened.
Right after
See if
the
I-
arrest, wasn't
Yes, right after this stuff. I'm going to show this to you guys. I just need to make sure I've got it off this stupid commercial thing. Okay, let me stop this for it'll not do that there. Okay, and I'll share my screen again. And so everybody has heard about, I got to be better at that. Some people may have heard about Richard Allen being taken to a hospital right after and during the time frame of this. I don't know what's happening in Mama Bear's world, but it's loud as heck.
Sorry, rain.
That doesn't sound like rain. That sounds like hail. Holy
Hey.
crap.
Sorry. I'm muting.
All right, let's see if this, let me make sure this shows up. Before you completely mute, which you probably just did, I need to know.
I'm muting.
Can you see this? Can you see this
Yes.
screen? Okay.
I can.
Hold on. It keeps wanting to start. Okay, guys, this is local news, Fox 59, confirming information immediately following the murders and a domestic incident at the Klein's home. So I want to play this for you. Here we go.
Our top story tonight at 6, the arrest in the Delphi murders investigation.
This evening, we're digging into the suspect's past. Thanks for joining us. I'm Birchelle Edmay.
And I'm Dan Spieler. 50-year-old Richard Allen of Delphi is charged with 2 counts of murder in the killings of Abby Williams and Libby German. And tonight, he's being held without bond in the White County Jail. Detectives with the Delphi Double Homicide Task Force took him into custody last Wednesday. Friday was his initial hearing when he entered a plea of not guilty. And tonight, we're starting to learn more about exactly who Allen was.
Today, our Max Lewis went to Allen's hometown and tells us why many he spoke with didn't see this coming.
Neighbors told us Richard Allen grew up here in the small town of Mexico, just about 30 miles from Delphi. We spoke to several people who knew him, and all of them said they never would have suspected him.
People change over the years, and I haven't seen Ricky for a long time.
Richard Allen, a.k.a. Ricky, grew up in this home in Mexico, but neighbors say they haven't seen him much since he moved to Delphi in 2006.
He was all around good, normal, everyday family. There was nothing out of the ordinary about him.
Before moving to Delphi, he lived in this home with his wife and daughter, according to neighbors. David Yoder lived across the street, but has known Allen since he was born and grew up with his dad.
Yeah, I mean, I would have never thought living across the road from him, there's anything. That's where I would have sent my kids to if there had been any trouble.
But after hearing Allen was arrested and charged with killing Abby Williams and Libby German, he's now questioning if he really knew him.
It's just hard to believe. He's a heck of a nice guy. Always has been.
Allen's parents still live in Mexico, but nobody answered the door today. Their neighbors describe them as nice people, but some still have a lot of questions.
I honestly just don't know how his parents could not, I don't know how they could not know.
Allen has no criminal history, but Carroll County dispatch records show he had one encounter with police in 2015. The sheriff said it was a domestic issue where Allen was supposedly drunk and his wife took him to a Lafayette hospital. No law enforcement action was taken, but deputies were sent to his Delphi home to, quote, keep the peace. If he's found guilty, his old neighbors say he deserves the maximum punishment.
And if he did do it, he deserves to fry.
Now, in this country, you are innocent until proven guilty, and people who knew him said they thought that was an important thing for people to remember. In Mexico, Indiana, I'm Max Lewis, Fox 50.
Okay, that was the 2015. There's another one that shows, now I'm trying to find where that is, but they talked about another incident that happened following it. It was in a couple of days afterwards. He had become drunk, and the police showed up for a domestic disturbance. And I'm looking through because I just dropped the new thing in Discord and now I can't find it. Hold on. Make sure I've got that. Anyway, it talks about kind of like a same case scenario where he's sitting here and has the police called. And then when the police are called, he's taken in to, instead of arrested, he's basically taken in to the hospital, and that he was drunk at the time. So, and that when they checked him, it was for a mental health check. And I just dropped this in here. Hold on. I'll be damned. Mama Bear, I don't know if you're able to look in the droppings that show the new place. They redid the look of Discord, and I hate it. Let me stress that.
You want to put everybody on.
I know. I don't like the new setup of it. And then I got this and dropped it in to just show you guys.
Did you just put it in Delphi?
Well, if I knew that, I'd be able to find it. I'm not sure where I dropped it now.
I think that's
I'm just trying to make sure if it's in the normal ones, I would have dropped it in. We've got so many stuff on this case. We have to keep it a bunch of times all over the place. We've got Delphi, Richard Allen, we've got research, we've got all kinds of crap in here. But yeah, so I'll find that and post that as well. But we know we had 2 incidents. We know we had one in 2015, but there also was one that happened in 2017. And it was on the 18th. And for some reason, they took him to the hospital. They declared it like it was like a mental health breakdown or something, you know? So that would be very interesting, because if it's drinking and stuff that he has going on, you know.
I'm sorry, JSC, I can't find it now.
Yeah, I don't know what I did. I put it in there if I could find it easily while we were on here with everybody that I wanted to show. But that's okay. I will get it, and I will link it out there for you guys. I will put the link for other stuff out there for you guys. We wanted to come on. There was a lot that happened. So again, just to share that big thing, we know that the attorneys are back in. Judge GULL is remaining. There is nothing to the denial for the, also about a speedy trial, because they never filed for a speedy trial. They can't give you one that you never filed for. And Mitch Westerman had his pretrial, 5 minutes long, in, out, gone. They did not allow cameras and stuff for that. So we're aware of that out there. And we have the additional charges that were put on Richard Allen by the prosecutor today, which add the charge of kidnapping and 2 charges of murder, in addition to the 2 charges of felony murder. Remember, felony murder, they just have to prove you guilty of committing the kidnapping and that led to their murder in order for you to be found guilty for that. And then murder's a different story. In my opinion, I think the murder part is a possible negotiation technique of this. You know, this is a higher charge. You can serve, you know, you can get death row for this. And that if you do know something and you know somebody who, I don't know, maybe set this up for you, then you need to talk. So that's my 2-cent view on that one. So we appreciate you guys coming in here at the last moment and doing all this with us. We were shocked of everything coming down. It comes down in droves. It's either nothing or lots and lots of shit. So
Ain't that the truth?
yeah, yeah. I'm hoping that this means that this case can finally start moving on. I'm sure we'll know soon what's going to happen. They wanted within 70 days. I mean, there's nothing changed except the fact that it's murder. But as brought up, are these attorneys qualified if this is a death penalty case? I don't know. I can't tell you. I'm not sure if they are qualified for that. I don't know if that will change anything up or not. But as far as all the accusations and the evidence that they brought to them, and everybody, that's what we've got to remember. We don't know what all the evidence is in this case. We've only seen what little theory that they wanted to on the defense side. We don't know everything they have. And even the bits and pieces that we've received, even just in Keegan Klein's, is so overwhelming. And yet some stuff is not there. So now I don't, should I share the rumor that I heard about the witness list, or should I not?
Maybe save it.
Okay.
Maybe save it.
We may have some witness list information for you, but we're not going to go there yet. Who knows? That may come out soon and then I don't have to worry about it whatsoever. But there may be stuff that comes out that really shows us that there is other people deciding to help with the case. I'll put it that way.
Yep.
So anyway, Mama Bear, thank you for jumping up on here, guys. I know if you've already watched the Supreme Court thing, you're like, oh God, not that again. But you know, I want to catch up for everybody. I did not go through all of it. I know for those who you didn't get to see it, I'm sorry. I will get the link. I'll stick this link inside the description of the video. You can go back and watch it to your heart's content of how many times you want to hear it. They did leave it that if the judge turns around and decides she wants to file charges against them for what they've done, you know, against their oath as attorneys, that stuff could still happen. That doesn't prevent that. You heard the judge bring that up herself, the chief justice, and you know, so we'll see what happens with that. And you know, they did not obviously see that Judge GULL did, you know, anything wrong, other than they didn't end up getting to the part where she would have documented that. We didn't get to hear that the prosecutor had evidence about the leak, and that's what the prosecutor was going to do. So if they would have not quit when they were back in Judge GULL's office and said, we're not coming out, when they came out, remember, cameras were there. We would have all seen what the prosecutors found about the leaker and everybody else. We didn't get to see that because they didn't come out for us to hear all of it.
Absolutely.
So think about that. I mean,
the prosecutor was prepared.
Yep.
I mean,
he was ready to present all of it and let the judge be aware what happened. And who knows if they come back and that's still brought out, maybe that's, you know, then the proceedings and stuff happen from all of that. But especially if they try any more shenanigans whatsoever. But they want to go. So let's see. Are they going to ask? Are they finally going to file that 70-day quick trial thing? Just because Supreme Court said it wasn't going through isn't because they can't happen. It's because they never filed it. So are they going to finally file something they had for 2 months from Richard Allen, who wanted it and he signed it? And it was supposed to be do my trial in 70 days. And then they never filed it. What about following his wishes that he's bitching everybody else about? So, so we'll see if that hurries up in there. Wouldn't it be nice if we thought something big was going to, but finally develop and move? I think that this, oh my God, you're being charged with straight out murder, the most serious charge in Indiana. That may even persuade a little more of, do I make a deal? Do I lessen how much time I can spend here, or even, for God's sake, save my life? And by talking and saying who else may be involved, in my opinion, we're looking for the Anthony Schatz who set up the meeting. That's who we're looking
Absolutely.
for.
I
And
agree.
could have done more, but I'm not going to go there tonight because that's a whole nother show. But if you've watched me long enough, you know what my thoughts are on that anyway. So, hey, I appreciate you guys coming in, clicking in, and staying in here. Thank you, Faye and Kelt and Miss Persevere. Hello, Mama Bear. Thank you for being up here.
Thanks for having me, GSG.
Yes.
I appreciate it as always.
If you want to know always anything that's up to date, I may not be a daily show, but I definitely do try to post any new breaking news always on the community page. So if you want to check if something's happened new, you can rush over to my community page because most of the time I'm dropping it as soon as it happens and as soon as I hear about it here in Indiana, so that you guys know about that. And we have some more stuff that we're going to be working on, and definitely some things about that I want to do, which is showing you guys a bunch of the people who have been busted for actual child production. And I think that is connected for certain, because I think they started to identify the other children that were in those videos, and they all started to drop like flies all of a sudden. So that's great news. That's wonderful news. So anyway, but again, thank you, Mama Bear, for being up here.
Have a good one. Thank you. And
Appreciate
thank you,
it.
everybody in chat. Bye-bye.
Thank you. All right, guys. Well, I do appreciate you. And I know this was a quick one and not as, full detail stuff. I will try to add copies of the documents for you guys to view too. We went through a couple of those. We'll watch Mitch's date. Like I said, is March 7th. We have dates coming up for Oakley Snow. We'll be covering stuff for Valerie Tyndall. We'll be having an update for the Debbie Fulton case. And other cases that we're following like that. I know people want that Jordan Sofer case. I may go ahead and do something on that. I know we've talked about it before, but I've not done an official show for it. That's a girl who was murdered and who was only 18. Her 29-year-old boyfriend at the time lived on 2nd Street in Peru. And she was found next to a creek in a wooded area. If you don't know about that case, but if there's cases and stuff that you guys want to hear about or cover, or if you have tips or suggestions or anything like that, please send me an email at justiceserveddaily at gmail.com. And, I'll look at that and see what stuff we can do. So I appreciate all of you. And thank you guys so much. Have a wonderful evening and keep making sure that justice is served daily. Good night, everybody.